Good evening, everyone, to today's webinar, which is on DPDP Law. And in today's webinar, we are going to cover the HR perspective on the DPDP Law framework. So whenever we have thought about DPDP Law, usually what comes into our mind is the customer data, the data privacy, the information technology systems, cybersecurity. However, one of the largest repository of data sits very close in any organization. It sits very close into the house at the HR function. What is that data? Employees' biometrics, resumes, background checks, exit forms, onboarding forms. Now, that's a lot of documentation that sits as a sensitive personal data with the HR function. With the Digital Personal Data Protection Act now shaping the way organizations collect, store, manage the personal information, HR professionals have a critical role to play in ensuring compliance while maintaining employee trust. Today's session is designed to explore the practical implications of DPDP law framework from an HR perspective. Rather than a technical or a legal deep dive, we will focus on the questions HR leaders and practitioners are likely to face in their day-to-day responsibilities. To guide us through today's discussion, we have two very excellent speakers with us. So let's move on to the next slide. Yeah. We have, first of all, our cybersecurity practice head, Narasimhan Elangovan. He heads the cybersecurity practice at Ascentium India, which is in Corp Advisory. He comes with a rich 15 plus years of experience as cybersecurity auditor, author, and he has been a keynote speaker at various global and national platforms on cybersecurity and data related events. He has led global engagements in cybersecurity audits, SOC 2, IT attestations, and emerging tech reviews. Nara has addressed 5,000 plus national and international audiences, including multiple ISACA CACS conferences worldwide. On the other side of the table, asking some real straight questions which are concerning the HR industry at this point of time is none other than Rujuta Rammohan, our Chief Cultural Officer at Ascentium India.
Wow.
She comes with a rich experience of 25 plus years of HR and L&D leadership across India and the UAE, specializing in organization development, HR strategy, and people-first transformation. Recognized thought leader and next-gen workplace leadership and the evolving future of work and a frequent speaker at industry events. Rujuta is also a certified agile HR strategist, professional life coach, and mental health ambassador. The reason we are bringing these experts today on the same platform is when it caught our eye on what was happening in the industry. We see these two new case studies that has brought to light recently with such multinational big companies like Ericsson or Mazda, the automobile company, where we've seen the breach of employees' data, the employees' personal data, due to the some kind of cyber activity. And this has brought concern to the entire HR fraternity, and a lot of questions have come up, and which is why today Rujuta has come prepared to this session with a lot of questions that Nara is going to answer it for us, for all of us. So over to you, Rujuta. Please, you can start shooting your questions. Thank you.
Sure. Thank you. Thank you so much, Dolly and Narasimhan. Nara, as we call you very, very fondly. So I will continue to address you as Nara in this whole session. I think it's an absolute privilege for me to share screen, share stage with you. Now, I've been in the HR business for the last 3 decades. And I think if there is one thing that has not changed as far as HR is concerned is the depth and breadth of data, whether it is employees or it is your interns, it is your project, your summer interns, it is vendors, it is partners. It's all the kind of data that comes, and thanks to the kind of transformation that has been happening in the systems. Whereas, we used to have, very, very old personal systems earlier, and we moved on to sophisticated HRIS system, HRMS systems, and today we have a lot of things which are cloud-based. We have AI tools working, all around what we do. And in such a scenario now, where there is, HR is in the midst of data handling on various platforms in various aspects. I think when Dolly talked to me about this topic and this seminar, I said that, one of the first things I need to do is we need to be educated ourselves as HR leaders. Because first is it's not so much about it is important. The compliance is important. For me as an HR leader, beyond compliance, it is the governance. It is the trust of the people, doing it right, through the right systems in the right way. So it is important for us to understand what are the myths around these, what are the realities that we need to follow, and ensure that our people's trust in us, when they send us, when they share their data with us, it is whether it is KYC data, whether it is personal information, whether it is behavioral information, all this is sacrosanct, and we are able to respect it and live up to their expectation. So let's get started, Nara. I have prepared a couple of questions for you. So my first thing is, when we think about personal data privacy, when we think about words like, data privacy, personal protection of information, the teams that come to our mind is either the IT team, the legal team, and even the cybersecurity team. So tell us how HR gets related in this entire, cube of DPDP Act, and some of the first myths that you'd like to clarify for all our wonderful participants who have joined this call today.
Sure. Thank you so much for the introduction and for this relevant question. Last few weeks, or rather months, where I've intensely been speaking to people on data privacy, personal data, most of the time it is the tech teams. And it's most of the time, hey, it is to do with agreements, complicated jargons, all of those. But let me tell you, the law says any person or an entity processing personal data. And the moment you start an organization, before even you have a website, before you have a tech team, before you have any sort of a conversation, even the first customer, you generally have your first employee. And that employee's data, you take it. What do you take? You take name, you take their email address, you take their phone number, which is bare minimum. But you go beyond that. You take the you take the PAN, you take an Aadhaar, you take maybe some address proof, some of the social IDs if it is applicable. You also go to the next stage where you take their parental information, children information. Some of them also offer insurance policy, so they take so much more details. Which means the first trigger point, let me tell you, is for every organization, they are employees and you are processing their data. Therefore, DPDP is applicable for you, whether you are actually a startup or any sort of a company, whether you're making profit, not profit, NGO, it really doesn't matter. If you have employees in your organization, the law is applicable for you. And very, very important, look at the places where your personal data is probably sourced from. I think that is where the first trigger gets started. So short answer to your question, yes, it is beyond IT, it is beyond legal, definitely applicable for HR.
Thank you. Thank you so much, Nara. That's very helpful. So obviously now all the next questions are going to be related to HR. Now that we know that, HR cannot be on the sidelines when it comes to the DPDP conversations, let's look at the next question where you have talked about personal data. Now, if you ask me, personal data, it is not just like you were talking about, It's not just about KYC documents. It's not just about salary information. Today, the kind of data that we are collecting across organizations, you have their behavioral patterns. We do so many of cognitive tests. We do psychometric tests. We also have, their performance management system. So you have people's performance ratings, etc., for a couple of years. You have emergency contact information. We also keep, the apps have become, the HRIS apps have become so, I would say high tech today, that we also have geofencing, which means we actually want to also track the location of our employees at times when it is, related to attendance, etc. So, what exactly is personal data for HR, Nara?
Fantastic. So the law says any data directly or indirectly we can identify an individual is personal data. I repeat, any data which says directly or indirectly I can identify an individual is personal data. Let's take a simple example. I say, hey, an IPL celebrity who played the last ball sixer in the recent matches happens to join my organization as an employee. Again, I'm making a hypothetical statement. But I think I have indirectly revealed who that person is. That, my dear friend, is personal data. So personal data can be any sort of an information relating it to a person. As I said, starting from basic information, probably your KYC related, which is required by law, move on to maybe data which is relating to parental, kids, etc. Maybe sometimes even your medical history, because sometimes if you're working in a type of industry, they require medical reports and prescriptions. Or maybe if you're working in a hospital has a policy that, for employees, I will give up to a particular limit, mediclaims by default, subject to you having passed our medical test and things like that. So all of these are personal data. And let me tell you, it goes beyond this, right? Something very interesting is any data derived of a person is also personal data. For example, a timesheet is also personal data. It's another matter how we use it for analysis and other things, right? Anything which is derived, right? You're storing some pin and some details, right? So it also goes beyond. So therefore, anything which you can identify, that is what is the trigger point. Now, sometimes organization, when they log into their premises, they also have the facial recognition. They also have a biometric. This also includes. And let me clarify that earlier we had something called sensitive and non-sensitive. Today, I don't think we are heading into that because the law has just defined personal data and thereabout.
Understood. That's almost about everything that we do every day. Am I right, Nara, in saying, and in any
That's the
format,
essence.
whether it
Yes.
is,
Yes.
I'm sure most organizations don't have paper files today, but any kind of digital file of an employee, any information that we have, whether it is collected on directly on our HRIS system or it is indirectly collected, through any other app, tool, social, WhatsApp, etc. Everything gets covered here. Is that correct?
Absolutely. In fact, you just made a mention of any systems. Many of the organizations have WhatsApp groups, right? So, assuming it's a small member organization, I know everybody. Some of them, what they would have done is they would have sent a link for a WhatsApp group and people join in there, right? Within the day,
Yes.
maybe it's for a fun event, whatever it is, right? Technically, I'm okay with being part of the WhatsApp group and other things. But what it also does is other employees get to know the mobile number of this employee, right? I can go to the number and I can probably see that. Now, that is something from a privacy standpoint may not be very appreciated. And when you're building an organization around privacy, all of these nuances have to be looked into detail.
Got it. So before I go on to the next question, Nara, help me understand uh, the personal data when you're saying, so the law is saying you can collect this data, but how you are able to guard this data and ensure that you are very, very responsible when you share this data somewhere. That is where the law comes in. Am I right in understanding?
You're absolutely right. You're absolutely right. The law does not say don't collect personal data. It's about giving that intimation and how you have to look into it. I think that gives
Got
you
it.
the answer.
Yes, yes, absolutely got that. So, moving on to, it's important for us to see go back to the previous question, please. The now we looked at what is DPDP Act, how HR gets, involved in the whole personal data collection and sharing. Obviously, now, when there is data, there are going to be HR processes. Now, I'm sure that some of my friends who have joined on this call as well, my HR fraternity, would like to know, when we have multiple HR processes that are there, in the organization, which are the HR processes we should, relook for the initial period, so that we are, kind of, any vulnerabilities that you want us to be wary of, that, we can mitigate any risk for ourselves.
Okay. So let's see the entire HR process journey, right? It starts from the very first step, which is identifying the prospect or candidate, right? That is where your touch point actually comes. Of course, you have a job description, etc. That's more internal. So you go to a recruitment engine, you go to a third party recruitment team, you go to LinkedIn Naukris of the world, try to gather and source information. Of course, there they have mentioned their mobile number and other things. That is the first trigger point for you to get it. Now, as soon as we get that, you start saving these people's profiles and resources within your systems, right? You may have some software, you may have some HRIS tools, as you mentioned, you may have a recruitment engine, whatever it is. And as though this is not sufficient, it goes beyond you probably taking certain vendors' help for questions, psychometry test. Today, some AI solutions are analyzing, the answers which you are giving, right, including interview assessments. So it goes through that entire cycle. Now, once this recruitment and that sort of a system is done, then immediately you say, hey, I want to verify, the background details, right? I may want to do certain verifications. Certain types of job also require police verification, external verification. So there are definitely touch points there. Then you move on, you have certain things where you onboard the employee, and that's when agreements, sign up, all of those happens, payroll is processed, and from there it moves to the cycle of salary payment, performance management, annual appraisal, and retrenchment. So if you see this exit and retrenchment, so the entire cycle, my dear friends, is covered, and each of the phases you are collecting a good amount of personal data. So my sense would be assess what are all the systems and how the information and personal data is coming into your organization. That, my dear friends, is the first touch point.
Understood. That is very, very helpful, Nara, which means it is my entire employee life cycle that I have to be, looking at. And irrespective of whether the process is handled internally or it is outsourced to a vendor, like for a payroll vendor or a background verification vendor or an insurance vendor, etc. It is important for us to take a holistic view of our responsibility. Is that correct? That's how
Absolutely.
I understood. Absolutely. Right. So now with that, let me move on to the next, question in terms of, there is today, we are talking about a workplace which is, thanks to the last couple of years, we have seen such a churn where, we had work from home, completely work from anywhere, remote working policies, to trying to get people back to work, and then, hybrid policies that came into effect. We have employees working out of homes, out of, while they're traveling. There are so many combinations that are there. Now, as far as the organizations are concerned, it has become such a challenge when you want to do even basics like attendance. There are even organizations today which have said, we want an automatic attendance. Like in my organization, we've actually done a pilot of that, because, why go through all that when when you want the employee only to perform. But by and large, organizations do have attendance tracking. Now that even attendance tracking will happen, multiple ways. Because it is all on an app or a biometric, or there is a CCTV camera in the office. So many things are there for facial recognition. Now, in all this, And our employees today, our people today are extremely, there is so much of knowledge, available, so much exposure. Obviously, their privacy matters to them, and they have become very vocal. And they've also become very, very aware of their rights, etc. So, in such a situation now, how should HR balance employee monitoring versus privacy?
Fantastic question. So let's understand what the law says. The law says for employment purposes, there is a legitimate use. That means it is understood that you need not obtain an additional layer of consent. You are permitted to use. But that word legitimate has to be very carefully looked into because it's for employment purposes, right? But that should not go beyond the fine line. The law also says I am okay if you want to monitor them because indirectly it is for protecting the employer from a loss, which is fine. But where and how do I head in that, right? How do I distinguish between how much is security and how much is over surveillance, right? Say, for example, I have an app which is logged into every employee system, which I want to use it for tracking maybe the time or what they're using. Step one. Versus I'm going to a stage where even the keys which they are typing or through a webcam, I'm sort of monitoring, etc. So that is where you need to understand the line which is necessary and where you're going beyond, right? Again, as HR, it is very important that you have a transparent notice system, a transparent policy, and a separate section within your documents, HR manuals, etc., explaining what, why, when, how, and also probably involve them saying that this is the reason why we want and this is how it is, instead of just trying to do detective's job out there, right? That is on one side. Second, it is also important that you need to understand that beyond the point, it might be challenging to prove to anybody that you are doing it for your own security and surveillance, but rather you might be overdoing it. So that is where the call from a employee monitoring and a privacy has to be taken. But please bear in mind, the law says anything which you do beyond the permitted limits or beyond the purpose may be treated as breach, and therefore the penalties may arise. So the breach is just not okay, my data is used by somebody else, or some of the news journals which Dolly started off by saying, hey, this organization lost some of this data. It is also some sort of a personal data which, if I am using for a purpose other than the purpose for which I have given, might be a breach.
Understood. Very well said. I think if it is used for any purpose other than the purpose for which it is captured, I think that kind of is the underline for me as far as this answer is concerned, and that also helps us understand that one is, I don't think we should be. I mean, I don't want to be scared of the whole act because that there may be a default and there may be a breach and there may be a penalty. I want to get away from that, but I want to understand. I got your point that as long as we understand where to draw the line and that we are consciously drawing the line, I think we should be safe. So with that, we will move on to the next question, Nara. This is actually very helpful. It is giving me good clarity on overall understanding of the whole act and the various aspects where it is touching. Now, there is so much that has been changing as far as HR is concerned, especially as the workplace changed. The workplace itself definition has changed, like I was still saying earlier, where, work from home, work from anywhere, or, everything where you can have your laptop and you are connected becomes your workplace. Now, we also recently saw, with the new labor code, the wage code, a lot of changes have got introduced. Now, a lot of times, what happens is, when acts come in practice, when policies come in, it obviously impacts how HR runs its internal, playbook. And when something of this magnitude is coming, do you see, as a very, very distinguished leader in this entire arena, do you see this is going to change HR? It is going to help HR evolve further as far as the whole employee life cycle is concerned?
Definitely, yes. Start from the trigger point where the data is coming in. Today, we collect so much of personal data with the assumption just in case we want this data, right? So that has to move from just in case or collect everything to what is the purpose, right? A purpose linked. Why is it necessary? Second, your storage might probably be in email systems, your third party applications. It could probably be in OneDrives or SharePoints. It might be spread across the ecosystem. So what is very important is to understand a specific place where this data will reside or minimize the touch points, because tomorrow you know that it is only in one place and you can always infer from that. And second, should an employee place a request for deletion of his data, right, you are able to delete the data subject to regulatory requirements, right? If the employee has worked for five years and you say that, hey, I'm leaving my organization, delete all my data, it might be tricky for you because you may have to keep it for regulatory purposes. You may have to keep it because a PF inspection might come and income tax audit may happen even after 5 years or 7 years. So therefore, it may be necessary. But let's say a recruitment candidate, you have taken their information and you're storing it in your portals, or maybe for, let's say, for 6 months or a year, and after that purging it, right? And after an interview process, whatever, and he says, I'm placing a request to delete my data, I don't want you to have my data. So these are the requests which we need to also honor, because the law says just like how you have an entry, you should also be having an exit. That means if the personal data request comes from the user, or what is called as data principal, that please delete my data, I should have a system to delete that information, of course subject to retention policy and requirements. And last but not the least, right, you might be using a simple thing like a CCTV camera. You might be having certain information which is there, or maybe an employee email log which talks about certain things, right? So these all change because you have to formalize the procedure, retention policy, etc., and communicate them. And that, my dear friends, is going to significantly impact. And many a times we use a third party vendor. It could be the Zohos of the world to the Great HR to, I don't know how many Darwin Box, I don't know how many payroll applications and, employee applications are being built. But I think it makes sense for you to check whether your vendor is compliant, because the law says if the vendor fails to show compliance, it is the principal, which in this case, the principal who's affected will send a notice, or, the law will have to, the expects us to demonstrate the organization collecting this data, it's called as fiduciary, to be held accountable for it. So whoever collects this data is called as data fiduciary, and fiduciary is held responsible for even the acts of the vendor. So definitely brings a drastic change.
I understood, Nara. So I think it's one of the things that came to my mind is I think it's important to start having, already organizations have empanelment process. There's so I think as part of onboarding any new partner, any new vendor that we are going to work with, it's important to get some kind of a, accept
A due
agreement from them,
diligence, yeah.
a disclaimer from them saying that yes, this is we are absolutely compliant, and we so at least there is something on paper, and because otherwise the number of vendors that you work with, I can think for an organization which is the size of 500 mid-sized organization today, will easily the HR department will be working at least with 6 to 7 vendors who could be small and large vendors as well. So, it is important for us to, if we are going to be responsible for, their actions, then we should make sure that we look out for, have some mitigation process when we are onboarding, when we are signing up with anyone. So I think that helps. So we've, I think, looked at data, we have looked at personal data, we have looked at HR processes, we have looked at employee life cycle, we have looked at vendors and partners, how it impacts. Now, if, this act has come into practice 2023, and I think there is, 2027 is when we can start expecting a lot of audits, and, we have to be prepared for that. So now when we are in the month of June 2026, what are the typical, 30, 60, 90 or a 3 to 6 months steps that, HR teams should take so that we are, well prepared for the DPDP world?
So my sense is start first from your touch points of personal data. Where does your entire personal data life cycle get going? Starting from pre-recruitment to whatever till the point where am I storing it? Can you bring all of them into one synchronized system? One software or one solution or one even a SharePoint, whatever it is, right? Because many times what happens today, we send the profile on email and it is sitting on email over there, and little do we realize that nobody's even bothered to check that, right? So check with where your personal data starts. It could be spreadsheets, it could be tools, it could be subscriptions, because you get access to some profiles basis subscriptions, and get an understanding of what are the key points. You might have a third party vendor whom you're hiring, for what purpose, how. So get this entire landscape fixed. Second, identify where this data is getting stored and see whether it can be kept up to date. It does not have every possible information with the presumption that I'll use it after 3 months, 6 months, etc. And ensure some basic security practices are there, right? The third thing is what you require, what I call it as a privacy notice for employees. So you need to have a privacy notice and some HR policies impacting this. I think that is also essential. That should give you some bit of a window for you to clearly communicate what it is, and ensure that all the HR members are updated of these requirements, right? Because the freshers to the new age colleagues to the Gen Z to outsourced organization, many organizations outsource PF ESI work to third party consultants, right? So even they should be aware of it, because accidentally some damage happens at their end, the responsibility could be very catastrophic, right? So some of the organizations, including multinational companies, are already compliant with certain global frameworks. So you may probably want to reuse certain things in the Indian context, because certain verbiage and the way in which the documents or the controls or other, the law is worded is a little different, and you may want to revisit them.
Got that. So I think that kind of helps. I think the biggest takeaway for me from that was the entire, data piracy notice that you talked about, which we should introduce, which should be, used as part of, whether it is in the internal decks or whether it is with partners, etc. I think that is, key. We should be prepared for that. And I think, we should look at where, what is the source or what is the starting point of the whole data. So I think most organizations today, mid-sized organizations, definitely, you have HR systems where you have, an application tracking system, and then, you have the HRI system, it all sits together. So the candidate, when you source a candidate and you screen, you interview, then you make, everything goes well, hopefully, and you hire the candidate. So then part of the data that you have collected of this candidate actually moves in along as part of the onboarding deck, onboarding process, so that there is no need for a duplication of action from the candidate when he becomes an employee, and then you start building on it. So I think one very important focus that our HR fraternity should keep is, how do we look at the start point of the collection of the data, and then, look at the data piracy notice as you talked about. So that was very clear to me. And I think, I am a chief culture officer, and, I think organization cultures, creating next gen workplaces, futuristic workplaces, and all subjects, mental, well-being are all subjects which are very, very close to my heart. Now, when you are talking about a law which is talking about all these things, I want to understand, one is to do it as a compliance. But other than that, I think it is going to require people to change their habits. Because it's so easy for us today to, a hiring manager is going to take an interview and he says, he calls my colleague, my head of recruitment, and says, I'm stuck somewhere and I don't have access to the portal, your great application tracking system. Just WhatsApp the resume to me. So, and we are in the interest of being very collaborative. All you're going to do is quickly download the CV, WhatsApp it to the hiring manager so that candidate is not waiting and you shared it. These are all small habits, Nara, which are all real habits, which all have the right intent, which are all in good intent. But these are all habits which kind of form the organizational culture. I've just given an example. You talked about examples about trust as well, personal data of people that is being shared. So tell me, how can DPDP help us strengthen? Because I think if there is an act which has been passed, it should be in the right direction. It should be for organizations to get better at what we do things and how we do things. So how will this strengthen organization culture, trust between employer employees and overall employer brand? Because, one mistake, one small thing today, social media can create havoc, with one slip up that you have. So please help me understand this.
So the sense which I think we should look at is, don't say I am doing this because there is a law and therefore I'm complying it, right? The law did not come all of a sudden. First, privacy was recognized as a fundamental right. And by virtue of that, when the Supreme Court recognized, then they said, hey, I think there is a sense to have a separate legislation for this. And that's where this act and other things is coming into picture. But what is very important for you to also understand is the way you position it. Use this as a strategic advantage to position how you want to showcase privacy within your organization, right? While on one side, it is compliance, but the bigger picture is that you have to value the employee's trust. You can't have all information of employee of an organization and do whatever mischief or maybe whatever monitoring, which is perhaps not legitimate or whatever is not necessary, right? That is something which will define. And why can your HR team or HR teams not act as privacy champions of your organization? Because you would be the person to be first be compliant, and it's all the more easier because there are certain exemptions given, there are certain permissions given for you, and certain things do not require mandatory consent, and fairly HR becomes a lowest hanging fruit. I'll also give another perspective. There's a lot of people who say, hey, DPDP Act is not applicable for me because I'm a B2B service provider. I am probably, dealing with very limited customer data, or I deal only with enterprise data, which is fine. But you are dealing with your employee data. So DPDP is applicable. Maybe the magnitude might be lesser, but definitely I see the applicability at that point in time. So my sense is use privacy as not as a compliance exercise, but rather as a differentiator to showcase where you're heading and what are you doing differently.
I completely, agree. And I think we would love to move towards a much, much more ethical, workplace across, whether it is a small organization, a large organization, across countries. I think today that has become such an important topic of discussion everywhere. How ethical are you? And I think that is what, it all leads to habits, it leads to culture, trust, employer brand. So I think it's all up to the HR fraternity to, walk the talk to ensure that we set the benchmark, we set the role modeling of, we mean what we say when we are talking about building trust and ensuring that the data of our people is safe. So I'm sure that, this is not limited only to, any specific industry or any specific size of the organization. So will there be a difference, Nara, for startups or large organizations, how they will have to deal with the expectations of DPDP?
So the foundational principles are the same, whether you're a startup or a large enterprise. The volume is definitely going to change, first thing. Second, for a startup, they may probably want to go with cloud-based, SaaS-based subscriptions. Whereas a large enterprise might say that we might want to have in-house applications. A startup might perhaps say, hey, I would use spreadsheets and probably a very lean approach and outsource to a lot of vendors. A large enterprise may have a lot of in-house teams and maybe limited amount of outsourcing. So principles are same. The way of you executing some of this is very different, right? Because that is where you need to understand how you can place reliance on all of those. So let's take an example, a small organization using a SaaS solution. You need to check how the SaaS solution is adhering into the data privacy requirements, right? And not just that, the SaaS solution says, hey, this is what I do. The rest of them is your obligation. So now we need to understand what is the obligation expected from us. It could be a simple access management. It could be maybe revocation of access. It could be whom you are giving the access to view all the details versus view limited information. Those all still form within the organization. If I'm subscribing to a SaaS solution, the access which I give to you as Rujuta or a friend as Dolly is something based on my discretion and based on the necessity of the job. So from a HR, I might probably give Rujuta you a perspective of every person's details, including emergency phone numbers, contact numbers, etc. Maybe to a Dolly, it will be restricted only to certain specific information and maybe details of her entire team because that is necessary for her, right? So that is where you need to understand the solution, what you're using, how the structuring is. And B, once you've identified the solutioning and structuring, whether it's a startup or large enterprises, what are the validations those vendors are making or promising you? It could be something to do with the tech stack. It could be something to do with the automation stack. It could be something to do with AI being used. How are those solutions compliant from a DPDP? Imagine there is an AI model which is running on the HR recruitment system on which personal data is analyzed and people are filtered. Okay, this fellow is good, this fellow is bad. And that I am not saying the AI model is doing wrong, but if there is a bias in that AI model, that is where we should be concerned about, right? So you need to understand that depending on size and expectation, things change. On the extreme end, you might have large enterprises who might say everything is in-house, everything is stored, and maybe certain things are strategically shared, right? But now you need to double check to the partner to whom I'm sharing, do I have data processing agreements? He or she, can they see the data? What happens if there is a misuse? What happens if there is a breach at the vendor's location? How do I get an intimation? What happens if I have placed a request, or an employee placed a request for deletion, and assuming I am required to delete, that means I've completed all the retention period, or I have completed the legal obligation. I have deleted in my system. Has my vendor deleted? Has my PF consultant deleted the data? Right? So these are all interesting and strange aspects which one should address, and this is where you need to get some perspective. The other last part of it, for a large enterprise, there is something called as a significant data fiduciary, which the government has defined. Basically, those entities who are fairly large and possess a risk, right? And the government is expected to notify. They have not yet said it is mandatory. The government will notify these are the categories. Let's say, for example, if you are having more than XXX thousand records, right? They might probably identify as an SDF. Now here they will only say personal records. So which means you have to read all your employee, you have to read all your customer and all of those and aggregate and say, hey, I'm processing more than 10,000 records. Maybe I'm an SDF, significant data fiduciary. So given that situation, it is very important that an SDF has a mandatory data protection officer. In addition to a data protection officer, the SDF should also have a mandatory data audit and a regular or a periodic data privacy impact assessment. So these are additional obligations for a significant data fiduciary, provided you get classified as such, right? I might have 1,000 employees and still not might get classified as SDF. I might have 1 lakh employees and still might not get classified as SDF. We'll have to wait for the regulatory framework. But the principles of employee personal data privacy notice are constant across the ecosystem, and it really doesn't matter based on size.
That kind of sums it up very very well, Nara. So I think the way I have gathered everything today on this entire webinar is, be it employee life cycle, be it the various vendors that we work with, partners and vendors that we work with, the various systems and tools that we work with from HR, the various processes that we run from the HR side, the kind of industries that we belong to, the size of the industry, none of this matters. It is important for us to take a very, very holistic view of where our employee data is, first of all, what kind of employee data gather, how do we store it, how do we share it, and how do we protect it? Because at the end of the day, I think all HRs, our common goal is always, how do you ensure that you strike the right balance between employer employee to make sure that there is enough trust and a great culture that we are able to build in systems, in workplaces, so that people have a good good mental well-being. People are happy doing what they're doing. There is enough good productivity, and everyone's happy at the end of the day. So that's the overall goal. So I think with that, I have really got very, very good insights today from you, Nara. I would, I'm sure if there are any questions that are there from anyone on the call, over to you, Dolly. We'll be more than happy to take them.
Sure. So we request everyone to pose their questions in the Q&A section of this webinar. Nara, we already have series of questions. So I'll go with the first one asked by Payal. She is asking who's responsible for protecting this data in the organization?
Within the organization, you will have to figure that out. But for me, as an external stakeholder, when I'm an employee or I'm a prospective candidate to your organization, I expect you as an organization to protect it. But within that, how do you build it? It is very, very specific. You become the owner of the data, and therefore you will have to check whether this application is subject to some basic checks such as encryption, safeguard, probably breach notification, and a bunch of those.
Perfect. Also, she wants to know what are the rights of employees under DPDP Act?
So the rights of employees are just like rights of any other data principle. Right to be heard, right for grievance redressal, right to erasure, subject to, as I said, the legal requirement. You could also have right for modification of the data, where I'm asking you, hey, modify some of these data. And you also have a right to nominate. That's a very unique provision that is applicable in certain cases where some rights you want somebody else to enforce. You can go ahead and do that.
Our next question is from Kannad Dasan. He wants to know how we can protect the physical data, which is in the paper form of the employees.
So the same standard protection mechanisms will apply, maybe safeguard lock, whatever lock and key and other systems. But let me tell you, the law focuses only on the digital personal data. But the word digital personal means data in digital form or data collected in physical form, which also becomes digital. So therefore, the ambit is fairly wide. But when you say, physical form, I would leave it to your best sense to how you protect it and safeguard it, maybe in restricted folders and, wardrobes and fireproof containers and things like that. But generally today, every data is getting digitized and stored.
Okay. So we had one more question from Payal, and it's a very important question, I'm sure, for most of the audience here, that how can HR store employee information securely? So they know the law, they know we have the data. How do we ensure that it is safe?
So first is understand what is the software and tech stack which you're using. Are you storing in Excel spreadsheets to OneDrives, or are you using SaaS solutions, etc.? When most likely we are using vendor somewhere or the other, please ask the vendor how are they compliant from a DPDP perspective. Second, please ensure that there is a data processing agreement between you as an organization. Of course, you will spearhead, and the agent or the service provider or whoever the third party is, the data processing addendum or agreement should be there mandatory. The third thing which is necessary is please ask them what are the security practices which are being followed. It could be encryption at rest, encryption in transit. It could be, who has access to the data, what are the access control, is there a possible backend access, business continuity planning, backup, disaster recovery. These are things. Generally the law says reasonable security practices, and it talks about a few things from a rule perspective, which is basically what I made a mention of.
Sure. So then the next question from Venugopal, and perhaps I think this pretty much also answers his question where he's saying HR using cloud applications like Zoho or any SaaS platform for that matter, should HR be worried if the data doesn't reside in their office but inside the third party applications?
Absolutely fine. Only thing is you need to get a comfort that the third party service provider like a Zoho or whichever you're using, they are compliant from a DPDP perspective. Do that vendor due diligence, have a strong DPA agreement with them. Sometimes you may not have a DPA agreement, so therefore you may want to, agree to their standard terms and references and clauses. I think that's the way you should go.
Okay. Next question from Sonia. She's asking, what about the employee next of kin? Any precaution to be taken when the kids become adults? I don't really understand this question.
Interesting question. Very interesting question. Even I have not thought about this. Technically, what happens is you are taking that data as a fiduciary, sorry, as a data principal. You could probably take their data and they can give the consent to you, but they become adults. Whether are you permitted to process? Actually, verbatim speaking, as per law, you cannot have it because it says that how can you have a personal data of a person who's not given consent, right? But having said that, I think this will go still under a legitimate purpose where the law is a little silent. Maybe some of the cases we'll have to treat it as voluntary disclosure and see how to take that particular information.
Okay, and so you made a mention of privacy notice during one of your answers. Sonia wants to know what exactly is
privacy notice in simple language is basically a privacy policy which you are giving to your employees. How you are dealing with data, what is the personal information, how you want to go about, what you process, what you don't process, to whom the data is shared. Of course, you need not name every vendor, but you can say that this is what it is. How do you purge your data? So you're talking about the entire data life cycle so that the person who's reading gets an idea and he is able to take a agreed decision.
And also she wants to know if there are any specific organization type where there is an exemption.
At this point, no. Only for certain government functionalities, there is an exemption, or the law, they say they need not obtain consent to process the data.
Sure. So next question is from Mr. Murthy. He is asking, for an NBC with branches across multiple locations, what should be the first 5 DPDP compliance measures that HR should implement immediately to ensure employee data protection?
See, first is try to have the data in one place as much as possible. See whether you're a centralized or a decentralized setup. If you are a decentralized, you will have to figure out how well policies are at each phase and probably ensure that all the data is stored only in one place. If you're centralized, I think your tools will probably help us out. Maybe you may have to start investing in tools. That is some necessary evil which we'll have to go through. And from there, I think the rest of them I already spoke, touch points of personal data, what is the journey, what is the life cycle. If you do that, I think that's a good enough start for you.
In fact, I would like to add, Nara, also the internal training and sense of ownership would be the very first step
Correct.
to
So
ensure the implementation.
Today, when we start off DPDP assessment, the first thing which I do is just explain what DPDP Act is. And then we move on to the rest of the information.
Absolutely. Okay. So the next question, how should organizations handle employee consent and privacy notices under DPDP, particularly in relation to existing employees whose data has already been collected over several years?
Very good question. So the law does not expect you to obtain a reconsent. The law says here is the updated intimation. And once you folks have gone through that intimation, if you have any challenges, please get back to us, or if you are not okay with it, get back to us. So it's more like a negative connotation. Only if you have a challenge, you sort of revert. Otherwise, it is implicit. So therefore, you make an updated privacy notice and you send it across to all of them.
Sure. Our next question is from Gaurav. He is asking, can we have DPDPA implementation sessions from Nara, sir? So somebody really wants you to take a workshop. Yes, Gaurav.
Interesting. We'll see that probably.
Yes, Gaurav. So we will leave you with our contact details in the end. Definitely, you can reach out to us, and we will definitely try and see if Nara can give some of his time for this kind of advisory. The next question is, what documents, policies, and records should HR maintain so that the organization can demonstrate DPDP compliance during an audit, lender review, ESG assessment, or regulatory inspection?
So I'll just give a couple of them to get started. First is your PII inventory or your personal data inventory and privacy policy. These are two first starting points. If you're a large organization, maybe your privacy risk register or a DPIA impact assessment. And if you have dealing with any vendors, how are you having a control over vendors? I think that's the typical starting point.
Sure. Our next question comes from Swati, and she wants to know for which data we have to take consent from employee and which will come under exemption of employee and employer relationship. And if it for purpose related as employee and employer, then for what purpose we need to take consent?
Okay. Swati, let me clarify. The law says first, consent is not mandatory for transactions relating to employee and employer, provided it is used for the purposes of employment and provided it is used for protecting the employer from a loss which can potentially be caused by an employee. So anything which is done within this ambit is fine. Everything else requires consent. A simple example, a fingerprint punching to a facial recognition will require a consent because it is not mandatory for the purpose of employment, employee, whatever, right? Now you can still say for protection of safeguard of measures and things like that, but we are going to the other extreme. So therefore it is recommended to take consent. On the flip side, let's say you're publishing a photograph of an employee in an annual report, that will also require consent, right? So there are extremes, have to evaluate every scenario. Hopefully that gives you a perspective on the answer.
Perfect. Okay, so Nagesh is asking the next question. There are lots of data company collect from employee how to strike a balance for employment purpose. Also, what if any candidate left the job or not joined the organization, how it's collected data dealt with?
So that is where, Nagesh, you will have to define your privacy policy where it say, this is the purpose for which I'm collecting and this is the period for which I'm retaining. So you can say if you have, let us say as a candidate, not joining my organization, whatever, I will still retain your data for 6 months because I have a policy that, within 6 months, they cannot reapply, right? So therefore I need to have a system and a practice how this can be taken care.
Perfect. Okay, we have lots of questions coming in and we've already reached our time, but we will go another 5 minutes to answer a few more.
Sure.
Amita is asking, can we expect a lot of litigation in the initial years after 2027, like for significant data fiduciaries?
Maybe yes. So I think litigation will take its own time. So there is a DPP board and then you have complaints. The complaints have to be filed with the board. Board may pass an order. You have to appeal against that order. Appeal is with the Telecom Regulatory Appellate Tribunal, which will sort of, oversee the requirements of DPDP law. And from there it goes to Supreme Court. So I think there is that course which we'll have to see.
Okay. Tanvir wants to know if there are any time period for employee data deletion after employee leaves the organization.
No, you will have to define it based on the retention policy requirements, which you will mention it. Ideally, I think Income Tax Act says up to 7 years. PFESI requires you to maintain data for 7 years. So I think that's what most of them are doing.
Parinita is asking, does the Act talk about till when the soft or hard data can be kept?
So technically, the deletion or the retention is always for digital personal data. But if you say that I will take a printout and delete my soft copy data, I would still say the printout came into existence only because of a soft copy, right? So therefore, it's still indirectly a digital form. So my sense is whether it's digital or hard copy, you will have to treat it on par.
Okay. Our next question comes from Varun, and he is asking a very different question. He wants to know, how do we navigate a data and information maintenance requirement under other laws such as direct tax law and indirect tax law? It comes to litigation. Say income tax requires books to be preserved for
You're
8
right.
years.
You're right. So you will have to develop a retention policy depending on act, situations, records, and probably take the highest of them and retain it. Now, for example, if you say that income tax requires 8 years, you may probably require PAN, Aadhaar, and maybe employee details. You don't require a timesheet. You don't require CCTV footages. You don't require audit logs of that employee for 8 years, right? That's where the difference comes into it.
Okay. I'll take, I think, one last question. When resume is downloaded from job portal, okay, is consent required from the candidate when the organization downloads the resume?
So if you see the most of the privacy policy or when you subscribe, the portal says that by you subscribing to our portal or you uploading the resume, we will share your resume to the approved recruiters. So there is an implicit consent which is taken by the recruitment portal, like an Naukri or a LinkedIn. But assuming we take that CV and we are contacting them, that's one side of the story. Then we take that CV and store in our records, and afterwards we are continuously contacting them, or there is a next recruitment drive, I'm sending a message or an email. That becomes a violation. So maybe contacting is okay, sending emails is fine, but the moment it is stored in our information and our sense, I recommend to obtain a consent, and you have to work around the process relating to that.
I'm sure Rujuta is right now thinking of how much data and downloaded resumes lies in her entire system of teams systems, right? I'm going to close with one last question, which I think is very important for entire audience. Is from Shirish. He is asking, can you specify implementation schedule of DPDP?
Implementation schedule, I think I gave a roadmap, start from typical touch points to contacts to applications and tech architecture to your entire life cycle, vendors, go through that. I think that will give you a fair answer.
Great. So we have a lot of more questions, and they are continuously coming in. But unfortunately, in interest of time, we will have to close this. So to just bring this entire session to a great conclusion, thank you so much, Nara and Rujuta. Nara, for giving your insights, and Rujuta for bringing this with the perspective of HR as a function, which is extremely, extremely crucial when it comes to employees' data, right? For our audience, you all want to keep yourself updated with our any upcoming webinars. We are going to still do a lot of DPDP webinars. Apart from that, we have other webinars. Please stay in touch on our LinkedIn. Follow us on our LinkedIn in Corp Advisory. For the questions that we couldn't answer today, please send them to us on info@incorp@advisory.in, and we will ensure that you get the response for that. For any queries, please feel free to reach out to us, and we will see you in our next session. Until then, thank you so much, Nara. Thank you, Rujuta, for your valuable time.
Thank you. Thank you so much, everyone.
Thank you so
And
much.
have a wonderful evening. Thank you.
Thank you.